Good afternoon. My name is Erin Choquette. I'm the CEO of the Connecticut Paid Leave Authority, and we will be talking about Connecticut paid leave in schools this afternoon. Just going to wait a moment as everybody comes in from the waiting room. As I put into the chat, we will be sharing a copy of the slides as well as the recording after the fact, so rest assured you will receive copies. If you have questions, please put them into the Q&A function, and I will do my best to answer the questions at the end of my prepared slides. If I don't get to your questions, or if you have follow-up questions, we will talk about ways that you can submit questions after the fact. We do have a great deal of information to provide to you, so hopefully some of your questions will be answered even before you think about asking. We are recording this, so again, you will receive a copy of the recording. If you do have questions, again, please use the Q&A function, not the chat, so that I can keep track of them. I am going to go ahead and share my screen so that we can get going. Okay. So today we're going to talk about Connecticut paid leave and coverage for non-certified employees at public schools. We'll talk about the Connecticut paid leave program. We'll talk specifically about the Public Act, which brings schools into our ambit. And then we'll follow up with some of the responsibilities of that you and your workers have under Connecticut paid leave and Connecticut FMLA. When you see the slide deck, you will see some materials that we won't go through today. We won't have time to do that, but we wanted to give you the resources you might need. So that will be in the appendix. This webinar applies to public school operators. Public school operators is a term that was defined in Public Act 25-174, which defines schools specifically to include local or regional boards of education, interdistrict magnet schools, state and local charter schools, as well as endowed or incorporated academies that have been approved by the State Board of Education to provide special education services, and cooperative arrangements between multiple boards of education as allowed by state law. Regional Education Service Centers, or RESCs, are included in the definition of public school operators, given that they are comprised of local and regional boards of education working together in a cooperative arrangement. Before we get into the details, let me just give you a quick overview about Connecticut paid leave. When we refer to Connecticut paid leave, we are referring variously to the Act, the program, and the agency. The Act was signed into law in 2019 to create a source of income replacement benefits for eligible workers who need to take time away from their jobs for qualifying reasons, which I'll discuss in a few moments. This program is for workers by workers. By that, I mean the program is entirely employee funded. The money comes from payroll deductions. So as the employer, it is your responsibility to deduct 0.5% from your workers' paychecks up to the Social Security contribution limit number. I will note that because we're starting in October, some of your employees may have already hit the Social Security contribution limit for purposes of Social Security, but you have not hit that limit for us. These payroll deductions are referred to by our program as contributions. So as the employer, you do not have to pay any money, but you have to process it by taking the deductions and remitting the contributions to the Paid Leave Authority on a quarterly basis, where it is pooled into the Paid Leave Trust Fund. This trust fund is administered by the Office of the State Treasurer, which invests it on our behalf, but it is not considered to be part and parcel of state money. It cannot be used by the state government or taken for any purposes. The only approved purposes for this money is to run the program and pay benefits. So if a worker needs time away from work for a qualifying reason, they will continue to apply to their employer for job-protected leave under FMLA, but they would apply to the Connecticut Paid Leave Authority to receive money if they need some assistance with income replacement while they're away from work. Although this program is new for schools, it is not new to Connecticut. Payroll deductions for most employers started in 2021, and we've been paying benefits since 2022. To date, we have provided over $1.2 billion in benefits to more than 165,000 workers. Actually, we're closer to 175,000 workers. And we have received claims from every city and town in the state. Just to note, if you do have questions, please put them in the Q&A function so that I can track them after. Since I'm sharing my screen, I cannot look at anything that's coming in during this presentation. I've referenced this already, but it's important to remember that FMLA and Connecticut paid leave are separate laws. FMLA is the acronym that refers to the Family and Medical Leave Act. There are actually two separate FMLAs. There's a federal FMLA, which you have been subject to, and a Connecticut FMLA, which only covers school employees, or only started covering school employees as of October 1st. FMLA provides job-protected leave. So these laws allow workers to take unpaid time away from work, and their job is held for them. These laws are implemented by the employer, so you process the leaves, and they're regulated by the state and federal departments of labor. FMLA does not guarantee income replacement. The laws say that an employer may permit or require an employee to use accrued time, but there's no obligation for an employer to pay employees while they're out. And that's the gap that Connecticut paid leave was created to fill. We provide money to eligible workers who are out of work for those same qualifying reasons, but we are not a separate source of job protected leave. A person can't say, oh, I'm taking Connecticut paid leave, see you later. They would say, oh, I need to take FMLA, and since I don't need some money to pay my bills while I'm out, I'm also going to apply for benefits through the Connecticut Paid Leave Authority, which is my agency. We're a quasi-public state agency that runs the program. The Connecticut legislature likes to use phrases that sound similar to reference different things. And a case in point is the Connecticut Paid Leave Program versus paid sick days. The paid sick days law requires employers to provide a minimum amount of PTO or sick time to their employees, excuse me, based on the hours worked. So 1 hour of PTO for every 10 hours worked up to a cap of 40 hours. Yeah, it's up to a cap of 30. 1 hour of PTO for every 30 hours work up to a cap of 40 hours of PTO in a year for a full-time employee. This law has been on the books for a long time, but in 2024, it was amended to significantly expand its coverage. So now it applies to virtually all employers, although it's being phased in based on the size of the employer. In 2025, it was further amended to allow boards of education and municipal employers, basically saying if you have a collective bargaining agreement that dictates the increments at which an employee can use their PTO, those collective bargaining agreements apply. Paid sick days is different than Connecticut paid leave. Again, paid sick days is funded by the employer based on hours worked, and it really can be used for almost any illness or injury, including routine colds and flu. Whereas, as we've discussed, Connecticut paid leave is employee funded, and it is used for really in connection with serious health conditions for the most part. We do have information on our website at ctpaidleave.org, and the Connecticut DOL also has information on their website if you need information about paid sick days specifically. But we're here to talk about Public Act 25174 and how it applies to schools in connection with Connecticut paid leave and Connecticut FMLA. Public Act 25174 actually did a bunch of things, but the ones that we want to focus on are these 4 elements. First, it established that definition of public school operator that we've already talked about. Second, and most importantly, as far as we're concerned, it mandates that employees of public school operators, as well as non-public elementary and secondary schools, who are not required to have professional certification pursuant to Chapter 166 of the Connecticut General Statutes, will now be covered by Connecticut paid leave and Connecticut FMLA. It also makes 2 technical changes relating to how we look at calendars, paid wages for determining eligibility, and addresses eligibility under Connecticut FMLA. I'll get into that in a few minutes. So, schools or public school operators are now covered employers under Connecticut paid leave with respect to employees whose positions do not require professional certification. Non-public elementary and secondary schools are similarly now covered employers with respect to those employees whose positions do not require that professional certification. To the extent you have employees whose positions do require professional certification, those employees are still excluded unless they collectively bargain to participate, which we'll talk about. So that's how we look at the employer. The law also amends the definition of covered public employee to include employees of public school operators whose positions do not require certification. Again, it's just another way of defining the coverage under this law. Let me just stop sharing for one moment. Okay. There we go. And so again, two ways of defining either the public school or the covered public employee, both with the same purpose, which is to say, your employees who are not required to have professional certification are now in the program for both Connecticut paid leave and, as we'll talk about, Connecticut FMLA. You have already been covered under federal FMLA, and there was a state law that provided leave rights that were similar to federal FMLA to your paraprofessionals with a shorter hours worked requirement. But now, as of October 1st, your employees whose positions do not require certification are covered under Connecticut FMLA, and the employees whose positions do require certification are not. So this phrasing of positions requiring professional certification under Chapter 166 has raised a bunch of questions. I believe the legislature used that phrasing because they wanted to adopt something that already existed and that schools were already familiar with. You already know which of your employees require certification. You're already tracking that to make sure they have the certification. And in many of the cases, it aligns with if they get retirement through Teachers Retirement Board. However, we know that there may be questions about new positions. You may just be uncertain. So we encourage you to check with the State Department of Education Talent Office if you are not sure if a position requires certification. This is the same talent office that you would use for any other certification-related questions. It's the same SDE district email address that you would already be using. If you here today are not the person who handles questions about certification, somebody at your school or Board of Education is, so please direct your inquiries through them. There were a couple of things that came up that we just want to flag for you, however. First relates to Durational Shortage Area Permit Educators, or DSAP educators. So we know that SDE allows educators who do not yet have their certification to temporarily fill positions that require certification under certain circumstances. The school has to ask for permission, SDE would grant it. Because the position does require certification, and this is simply a limited exception, we still consider that position to require certification. Therefore, the people who are filling that position are excluded and not eligible for Connecticut paid leave. We also see questions on the other side of the coin, folks who may have certification but are in a position that doesn't require it. We have heard that some schools would prefer to hire folks who are certified for roles like paraprofessionals, even though the position is not required by statute to be certified. When you have a preference like that, that is a preference, not a requirement. And so those paraprofessionals would still be covered under the program, notwithstanding the fact that the person who's filling that position might have certification. We also have received questions about folks who might have dual roles within the same school. Perhaps someone is performing work that requires certification, but then has a secondary position where the work does not require certification. We would look at their primary role to determine if they're covered or not. I mentioned before that there were two technical changes that were also adopted in Public Act 25-174. One relates to how the Connecticut Paid Leave Authority determines somebody's wages for purposes of eligibility and benefit calculations. For us to determine if someone is eligible for the program, we look at their quarterly earnings in the base period, which is the first 4 of the 5 most recently completed quarters. We know that there are positions in various schools where the employee is given the choice of selecting their payment schedule. They could be paid on a 10-month schedule, they could be paid on a 12-month schedule, they could be paid 10 months plus a balloon payment. Where the employee is given the choice about how frequently to be paid, then we are going to determine their quarterly wages by taking their annual wages and dividing it by 4. We do this to ensure that we are treating folks who are in the same position with the same wage scale and who are greatly making equal contribution payments equally. We don't want there to be folks whose quarterly wages are artificially high or artificially low simply by the happenstance of how they chose to be paid, probably a long time ago. There's a second technical eligibility change that came about in Public Act 25-174, which relates to Connecticut FMLA. Since 2022, the eligibility standard for Connecticut FMLA has been that an employee has to work for their employer for at least the 3 months immediately preceding the leave, and DOL translates that to 13 weeks. When the legislature was looking at adding school workers, they were concerned about the potential impact of the summer break. And they wanted to make it very clear that a summer break should not take someone who would have been eligible and deny them eligibility for leave. So for non-certified employees of schools who are eligible for FMLA, if they show they were employed for at least 3 months during the previous 12-month period by that school. All right, so we've been talking about how the laws have changed to include schools, but let's talk about what it means now that you guys are part of these laws. On the paid leave side, there's really 2 halves to the program. There's the contribution side and the claim side. As I mentioned before, the worker pays the money. And Connecticut is an employee-funded state, unlike some of the other states where employer has a share. Here it's fully the employee's responsibility to pay, but the employer has to process those payments. To do that, the employer must register with us at ctpaidleave.org, deduct the 0.5%, and remit the contribution to the authority. If you use a TPA, a payroll provider like ADP or Paychex or whatever, they are probably processing, hopefully they're processing your payments, but they're not going to register for you. You still need to register. I want to point out for you that even though it's the employee's responsibility to pay, if the employer fails in its obligation to take that payroll deduction and remit it to the authority, the penalty for that includes the employer now being responsible for all of those missed contributions, as well as an additional penalty of 10% or $50, whichever is greater. We at the Paid Leave Authority receive and reconcile the contributions and process any over or underpayments and will impose penalties for noncompliance. So I really want to urge you to get yourselves registered and make sure that you're taking those contribution deductions from your employees' paychecks. The deductions are owed for any payroll that was issued on or after October 1st. So we're already into this responsibility. If you haven't registered already, you can go to our website at ctpaidleave.org, look for how to register as an employer with Connecticut Paid Leave. When you do so, you will note that we ask a few questions, including your business type. You will most likely be registering as a public school operator. You will also be asked when you first had Connecticut workers. This is a standard piece of our registration. We know you've had workers since before October 1st, but since you are newly covered under this law, please enter October 1st on that date. If you do have questions, please go ahead and put them in the Q&A so I can address them at the end of the slides. When you register, you may also request approval to access basic information about your employee's claim status. This is in addition to simply registering. You would actually have to do a separate request to get this claim access. It's basically a report where you would see your employee's name, their case number, and if it was approved, the dates of the claim and weekly benefit amounts. Instructions on how to do this is also found on that Employers tab on ctpaidleave.org. It's not required, but if you would like to get that report, you're welcome to go ahead and process this step. Again, just to give you a little bit more detail on the contributions, it's the 0.5% based on the wages as calculated for FICA. So you include the things that you include for FICA, you exclude the things you exclude for FICA. You have to give it to us on a quarterly basis, but we do allow a 1-month grace period before any penalties would apply. So technically for fourth quarter of the year, the payments are due on December 31st. But as long as you get them into us by the end of January, you are in good shape. You will not be late. And then the other side of the coin is the claim side. Employers have limited involvement in the claims. The worker would apply directly to Connecticut Paid Leave, either by going on our website or by contacting our third-party claim processor, AFLAC, to start their claim. We will ask them for documentation to support their claim. They are required by law to notify you that they have applied to us for benefits. Many times, the employer is the one saying, hey, you've applied to us for FMLA, you should consider applying to paid leave. But sometimes the employee comes in first to us and then goes to the employer and says, hey, I've applied for paid leave. Here's a form that they need you to complete. We call it the employment verification form. So sometimes that is how they notify you that they've applied to us. We have a special school employment verification form that asks the information we need, which includes the employee's schedule, if they're certified or not, if they have the ability to choose their payment schedule, that 10 months, 12 months, as I mentioned, and if you're going to pay them anything while they're out on leave. An employee can receive benefits from both the paid leave authority and the employer concurrently, provided the total amount does not exceed 100% of their wages. So we need to know if you're going to be paying them because we need to adjust what we pay accordingly. And of course, the employer is responsible for not discriminating or retaliating against their workers who file a claim. Once we get the documentation from the employee, including the employment verification form, which you as the employer would either provide back to the employee or email or fax to us directly, we will review the claim, approve it if we can, make the payments directly to the worker. We do monitor the claims and we do investigate potential fraud. If we deny a claim, then the worker can file an appeal with DOL. I mentioned earlier that employees of public school operators whose positions do require certification, such as teachers and most administrators, are not covered under Connecticut Paid Leave unless they collectively bargain to participate. If you have employees whose positions require certification who are not covered by a union, and you have employees whose positions require certification who are covered by a union, and that union bargains to participate, then the folks in that first group would also become participants of the program. If you have multiple unions representing different certified folks, only the folks who are represented by the union that bargained for the participation would continue to come in. Folks who are in a different bargaining unit that did not want to participate would be excluded. Just so you know and aware, we do have a policy about how this works. For us, the most important thing is that we know about it so we can process it. And two, that the participation has to be a prospective date. There can be no retroactive participation because we're an insurance company and that's just the way insurance companies work. You should also know that if you collectively bargain for participation into Connecticut Paid Leave program, that does not automatically change the employee's rights to job protected leave. You can't collectively bargain into coverage under Connecticut FMLA and expect Connecticut DOL to enforce it. but you could bargain for a policy that adopts the provisions of Connecticut FMLA, in which case it would be enforced through the regular grievance process. Talking about FMLA, this is actually the area where the employer really is the one leading the charge. The employee still has to tell you that they need time away from work, but the employer has to process the leave request. So if you don't already have a leave policy, you really need to adopt one that includes Connecticut FMLA. And you need to make sure that you're processing the leave request, understanding the new eligibility rules, again, communicating with the employee about what documentation they need to provide, and of course, refraining from discrimination. If you have questions about FMLA, you would really go to Connecticut DOL or federal DOL to make sure that you understand your obligations. What we suggest you do as a newly covered employer under Connecticut FMLA is make sure that your leave policy includes references to Connecticut FMLA. We strongly encourage you to be very clear about what you do and do not require in conjunction with your PTO. Do you make people use their sick time if they're sick? Do you allow them to use their sick time if they're a caregiver? There are posters that you need to provide. You do want to make sure that your employees understand the rules, including whether or not they have to call in when they're out, if they need to notify their supervisors, and again, making sure that they give you the documentation you need. Even if you have a worker who says, I don't want my time off to be designated as FMLA leave, you should know that in all circumstances, it is the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA. If the employee is eligible and the leave reason counts as FMLA, you want to track it as FMLA. So I keep referencing the leave reason. What am I talking about? Well, there are 6 covered leave reasons. The first is really an umbrella term. It's medical leave for treatment for one's own serious health condition. This is when you have a serious health condition which itself causes you to be incapacitated. So you're unable to perform your regular functions at work or at school. But it also includes treatment for that condition, as well as being incapacitated from the treatment. Technically, the term medical leave includes serving as an organ or bone marrow donor. It also includes pregnancy and recovery from childbirth. We treat those as separate leave reasons, but they're all under that umbrella. In addition to medical leave, employees can take time off for bonding. That's to bond with a newborn child or newly placed foster child or adoptive child. It can also be used in advance of the placement for time needed to process the adoption or placement. Bonding leave can be used by the parents, but only the parents. The definition of parent includes biological, adoptive, foster, as well as sort of the adult who's going to be raising the child, right? Even if there's not a legal relationship. Bonding can be used anytime during the first 12 months after the birth or placement with foster care or adoption. But once that 12-month mark is up, you can't take bonding leave anymore. Caregiver leave is leave that's available for a worker to provide physical or psychological care and comfort to a family member who's experiencing a serious health condition. This could involve taking them to the doctor, meeting with the doctor, visiting them at the hospital, or just being home with them, right? Just being there to provide that care and comfort. It does not require any sort of medical training or physical laying on of hands, but they do have to be present. Military caregiver leave is a special kind of caregiver leave that's available if an employee has a family member who's been injured in the line of duty on active duty in the armed forces. The thing that makes military caregiver leave special, under federal FMLA, it's the only kind of caregiver leave that has a broad definition of family. Connecticut already has a broad definition of family, and it actually allows 26 weeks of job protected leave, which is different. Everything else is less. We at Paid Leave Authority can only pay 12 weeks of benefits. So someone might be out for caregiver leave longer than we can pay benefits for. There's also something called the Military Qualifying Exigency Leave. You would see this if you have an employee whose parent, spouse, or child is either on active duty or has been notified of an impending call or order to active duty. There are 9 qualifying circumstances that count. They include things like attending a sending off ceremony or a welcome home ceremony, or updating your will and power of attorney because your spouse is being deployed. Then there's the Family Violence Leave Act. This is technically separate from FMLA, but it is a statutory entitlement that's been around and applied to schools for the last decade. It provides job-protected time off to a worker who is a victim of family violence. As of last year, it also includes individuals who are a victim of sexual assault. And they can use this time to obtain medical or psychological care or counseling, to obtain services from a victim services organization, to relocate if that's necessary due to the family violence or assault, or to participate in a court proceeding. Family violence leave is limited to 12 days in a calendar year. So we would provide benefits for those 12 days if someone is out. Now, I mentioned before that a serious health condition is different than just being sick, right? There is a multi-pronged definition in the statute, but it boils down to being incapacitated. So you don't have to be in the hospital, you don't have to be bedridden, but you're not able to perform your regular daily functions and activities. It also requires some form of treatment by a healthcare provider. So it could look like an overnight stay in a hospital, but it could also be a chronic condition for which the employee is getting treatment from a healthcare provider at least 2 times a year, but they don't necessarily have to see that healthcare provider every time there's a flare-up. If they get a migraine, they don't have to go to the doctor each time because they've already been sort of certified as having migraines. It also includes long-term conditions for which treatment may no longer be effective. So now we're looking at palliative care, but the patient is still under medical supervision. And finally, it's important to note that it includes pregnancy. The statutory definition talks about incapacitation during pregnancy, but pregnancy itself is considered to be an incapacity by statute. And so things like prenatal appointments are covered, as well as complications during pregnancy. When I was talking about military caregiver leave, I mentioned that federal FMLA has a very narrow definition of family, unless you're talking about military caregiver leave. For regular caregiver leave, federal FMLA says you can only take it to care for your parent, spouse, child who's under 18 or 18 and older, who has a disability as defined by the ADA, which prevents them from engaging in 3 or more activities of daily living. So it's a very small circle. Connecticut FMLA and Connecticut paid leave, however, have a broader circle of family. It includes a parent or spouse, a son or daughter of any age, as well as a sibling, a grandparent, a grandchild, or an individual who's related by blood or affinity. This is shortened to be related by affinity. It means any person with whom the worker has a significant personal bond that is like one of those family relationships, regardless of a biological or legal relationship. So this is obviously very fact specific. As an employer, you can ask your employee to give you a simple writing explaining how the person they're caring for is equivalent to a parent, spouse, sibling, child. But you cannot ask for an affidavit or a notary. You certainly cannot ask for photo albums and family videos. We often see people are requesting related by affinity because they have a long-term relationship with somebody with whom they're not married. Connecticut does not recognize common law marriages, so Goldie Hawn and Kurt Russell have been together for decades but never got married. So up until Connecticut's law changed in 2022, if Goldie got sick, Kurt would not have been considered to be her spouse, but now he is. Just a note on that. On our program, we have a form that anyone who's asking for caregiver leave checks the box as to which one they're caring for, and then there's a space to explain the affinity relationship. The Connecticut Department of Labor has a similar form that employers can use if you choose not to use the form that comes with our program. It's important for you to know that there are different ways that employees can take leave. I think most people think about FMLA leave, if they think about it at all, when they think about block leave. So someone who's out of work for a single qualifying reason for a few weeks or a couple months at a time. So someone's having a baby or they're out for surgery and is going to be out for several weeks. And we see that a lot, but that's not the only way people can take leave. You can take reduced schedule leave, which is when you work some of the time, but not as much as usual, such as someone who has to leave work at 1 every day to go to physical therapy. So they're still there, but they leave work 2 hours early. Or you have intermittent leave where you're absent from work sporadically for relatively small amounts of time, but for a single qualifying reason. This could be caregiver leave where you're taking a family member to the doctor, or it could be their own chronic condition where they have flare-ups. Connecticut FMLA and Connecticut paid leave operate with 12 weeks in a 12-month period for most leave reasons. As I mentioned, military caregiver leave, you can actually get 26 weeks of job protected leave. But for the rest, it's really 12 weeks with 2 exceptions. Our law says that a person who is pregnant may access 2 additional weeks during their pregnancy if needed for either incapacity or treatment. Once the baby's born, even if they haven't used those 2 extra weeks, they go away. And then, as I mentioned before, the leave under Connecticut Family Violence Leave Law is capped at 12 unpaid days. I think it's important to note that all of these are up to. If the doctor says you only need 3 weeks, then they only get 3 weeks. They don't get to stay out 12 weeks just because the law allows for up to 12 weeks. So some things for you to remember when you're talking about this. Now that you're subject to both Connecticut FMLA and Connecticut paid leave, there is a notice that you are required to give to your employees. The statute says you should give it to them annually and upon hire, or chronologically upon hire and then annually thereafter. I would encourage you to send that notice out now since you're all newly covered. The notice is available on the website. I did include a link to it in the chat before the Zoom started. Again, applying for paid leave is not the same as applying for FMLA. Your employees should apply to you, the employer, for FMLA, and then they can apply to paid leave for the money. For us, an application is not complete until we get all the required documents. So that would be identity verification, that employment verification form, and a document that relates to their leave reason, like a medical certificate. We do give an extension of time, but we also urge folks to let us know if they're having trouble. As the employer, you are required by law to complete that employment verification form. Even if you think they're not eligible, whatever, complete the form. There's space for you to tell us if they're not on leave, you can tell us that, but you don't want to set yourself up for an interference claim by refusing to complete the form. We do have a job aid to make it easier. If you have trouble completing the form, you can check out the job aid. And finally, this is true for all of our workers, but particularly important for schools. Benefits are paid only for the dates that the employee would otherwise have been scheduled to work, but for the leave reason. In other words, if someone's not normally scheduled to work in July, the employee can't get benefits in July. All right, I'm just going to pause on this page for a moment and then I'll go to the questions. If we don't get to your questions or if you think of questions later, you can go to ctpaidleave.org. We've got tons of information for employers, for employees, about the program, their videos. There's a lot of stuff there. But if you still have a question, you can click on the Contact Us page and submit your question to us, letting us know if you want an email or phone call back. Once your employees have filed a claim, and if they have a question about their already filed claim, they can go into their portal or call AFLAC to get status updates. If anyone has questions about Connecticut FMLA, we really send you over to the Connecticut DOL. The link is here, but it's also in the chat. And questions about federal FMLA, go to federal DOL. All right, questions have been coming in fast and furious, so let me look. So the state's website, will the state's website be updated to reflect the new laws? So our website is already updated and includes the fact that Connecticut FMLA and Connecticut paid leave cover workers. If you're talking about the Connecticut General Assembly's website, you really could just do a search on their search function and look at Public Act 25174, and that'll give you a copy of the legislation. The legislature updates its statutory citations every January. So question, can you use 12 weeks of federal and 12 weeks of Connecticut FMLA in one rolling year? The rolling year is a great question. The employer gets to decide what they use for their 12-month period. It can be a calendar year, it could be an anniversary, like date of hire, it could be rolling, which is recommended. So that's what we use. The first day that a person takes leave, they'd use 1 day. And then a year from now, 365 days from now, they get that day back. That's part one of your question. Part two, do you get federal and Connecticut FMLA concurrently? Mostly, it depends on whether the person is eligible under both federal FMLA and Connecticut FMLA, and if the leave reason counts. If both of those statements are true, then they're drawing on their federal FMLA and Connecticut FMLA at the same time. So they're not stacking, they're running concurrently. If they're taking leave for a sibling that's not covered under federal FMLA, so they're not touching their federal bank, they're only using their Connecticut FMLA. So you might see more than 12 weeks in that situation. Question about contributions. Can you send them in on a weekly basis via ACH? Yes, we will accept them on a weekly basis. You can remit them through ACH. If you go to our website, there's all the instructions you would need about how to remit the contributions to us, including sort of the routing number and the file specifications. What do you do if you didn't start taking out the 0.5% in that first paycheck because you were saying it was due and that was September work and we thought we didn't have to do it until the 17th? I will tell you that what has happened in the past is that folks have reached out to Connecticut DOL to get permission for sort of a quick one-time or sort of short time only to take an extra contribution out of the paychecks just to make up for that. So you could reach out to Connecticut DOL and just get permission to do that so you can take out 1% out of one paycheck to make up the difference. That's what I would do. Sorry, I'm just trying to get back to these questions. Employees that are granted Connecticut paid leave will not be paid for holidays. Is that correct? So whether you pay them for holidays is totally up to you and your policies and collective bargaining agreements if you have any. As far as what we pay, if they're out for, if the holiday falls in the middle of a block and we pay them by week, they'll get paid the weekly amount. But if the holiday is at the beginning or ending of a week where they're partly working and partly not, then they don't get paid. And then again, if they're not scheduled to work at all for that whole week, they would not have been scheduled to work at all for that whole week if they had not had a leave reason. We wouldn't pay for that. Is there a job aid for the employment verification form for school districts? Yes, it's recently been posted on our website. If you look at the claims page and the document checklist, you will find it there. If an employee returns sooner than their approved benefit period, is it the employee's responsibility to notify the authority? Absolutely. We tell them that is something they have to sign off on and they let us know. And if we pay them longer, they owe us the money back. Are our staff eligible to receive Connecticut paid leave even though they've not been contributing before 10/1? Yes. So the law said that they're eligible as of 10/1, so they're covered as of 10/1. We will look at their earnings from the past 5 quarters in our eligibility standard, even though that was earned before coverage, it still kind of comes in because of the new law. So yes, people can start receiving benefits now. Yep, we will be sending the recording to the participants. Does an employee have to exhaust all of their PTO, sick, vacation before applying for benefits? Great question. The classic employers or lawyers answer is it depends. And it really does. It depends on your policy. You are allowed to have a policy that tells people how they have to use their time off. So if you have a policy that says they have to exhaust their sick time or whatever, they have to do so. However, and there is a caveat here, Connecticut FMLA says employers are not allowed to require employees to fully exhaust. They have to be given the opportunity to hold on to at least 2 weeks of their PTO that they can use for another reason. So you could say exhaustion, but you have to allow them to hold on to up to 2 weeks. And then we would start paying sort of after that. An employee is not required to be approved for FMLA before applying for CT paid leave. Ideally, they will happen concurrently, but an employee could start with us and then go to you. They might start at the same time, but we act faster. That's fine too. We just want people to know that they have to do both, because getting the benefits from us does not mean that they have job protection from you. Someone has an employee who's applied for paid leave and wants to use their sick time to make up the rest. We don't know how to do that until we know how much she receives. So, first, that is totally your decision, or subject to your collective bargaining agreement if you have one, about whether you allow people to top off the benefits they receive from us with the benefits that you have already paid. That's perfectly allowed. You do or do not have to do that. That's up to you. You will find out if she gets approved. We will send you a notice. Even if you don't sign up for the report that I mentioned, you will get an email. Whoever filled out the employment verification form is asked to provide an email. We send an email that says this person was approved. This is their weekly benefit amount. You can also make your employee give it to you, right? You can tell them that you need proof of the payment. We turn around our decisions within 5 days of getting all the documentation that we require. We're averaging about 3 days. So, you know, it's pretty straightforward in terms of getting as soon as we get the forms, we look at it and we make a decision pretty quickly. All right, I'm gonna skip a couple of the certification questions for a moment. Oh, I'm an HR manager. When you register, they're asking, should I be called the benefits coordinator or the company representative? We offer different roles because sometimes companies are larger. So the benefits coordinator person is also a person who we would expect to be interested in things like how the claim process works. And we might be contacting them in connection with the claim process or sharing information about that. Whereas a company representative might be the fiscal manager and who doesn't have anything to do with HR. It really helps us know for things like newsletters. It's not the most important thing in the world. You could be either and still apply for that separate access to claim. So, pick whatever feels right to you. I have an employee who's told to complete the original employment authorization form and the non-certified staff one. Do they have to do both? No, they don't have to do both. That was an error. As we switched processes in October, there were a few folks who got both. Really, the employment authorization for non-certified staff is the one that schools should be completing. So, and if you want to message me separately so I can make sure our staff knows and we can correct the account so that they don't get told they're missing something, please feel free to do so. If a non-certified employee began their federal FMLA on 9/1 and then they become eligible for Connecticut FMLA on 10/1, do they get new time? Yes. So they would have started their federal FMLA on 9/1. They start their Connecticut FMLA on 10/1. So basically they get access to about 4 weeks of extra leave due to this new law. They don't get 12 plus 12, but they would get sort of 4 plus 12, if that makes sense. We have students who work for the school during weekends, during school breaks. What do we collect for them? If you are paying W-2 wages, if you're paying wages and you give them a W-2, then you would have to do the deductions for them as well. I will say our eligibility standards are pretty generous. It does not take a lot to become eligible. So particularly if they have other jobs, that would all go to sort of what their kind of wage profile looks like for us. But again, anyone for whom you are issuing a W-2 who's not required to have professional certification, you would do the deductions. What are the rights of part-time non-certified employees who do not receive sick time? All the rights I said. You don't have to receive sick time from the employer to be eligible for Connecticut paid leave. For qualified employees, does withholding tax apply to all payment types, including stipends? We've got a few folks who are asking about stipends. I am going to get back to you on that because we're getting clarification from Department of Education, so stay tuned. Another question about certification, school psychologists, social workers. If they're part of the union, does that mean they're certified? Again, that's really a question for the State Department of Education. And they're the experts, so I'm not even going to opine. Being part of the union does not necessarily mean that they're certified or required to have certification, so it really is a State Department of Education question. So how do we determine the certification status? We ask on that employment verification form. That's one of the questions we ask. So we don't make that determination ourselves. We ask you if this person is certified. And if they are required to be certified is really what we ask. So if you have a teacher who's certified but working in a para role, you would tell us that they are not required to be certified. A question, you said that we all pay in. What if they don't make the earnings minimum? Well, we look at all wages in the base period from all covered employers. So we know that there are a lot of folks who might have multiple jobs, and we look at all of that to determine the earnings minimum. But so generally speaking, that is what sort of is part of the reason why y'all have to do it. But regardless, the law says that if you're covered, the contributions have to be deducted. So even if somebody, my dad worked part-time at a golf course. He never made it, but he always contributed in just because that's what the law says. Sorry, retirement job, only worked 4 hours a week, kept him in golf, but he still had to pay it. Our staff members who do not possess educational certifications such as school business, the 085 cert holders, do they contribute? Again, great question for State Department of Education. I do know that the business administration question is thorny. We've learned that. So great question to ask the State Department of Education Talent Office. Okay, just gonna go back. I know I specifically skipped the stipend questions. I know I skipped them, and we will get back to you on those questions. Just want to make sure I covered the others. Substitute teacher. We have several subs who work both certified and non-certified coverage. Again, good question for State Department of Education. They have talked about permanent subs and non-permanent subs, but really you want to be looking to them for guidance on, is a person holding a position that requires certification? All right. Other than the stipend questions, it looks like I've answered everything that came in. Oh, are there separate Connecticut FMLA forms from the federal FMLA forms? Connecticut DOL does have Connecticut FMLA forms. So, I would check out the Connecticut DOL website that is in the chat and check out the forms that they use. It would be lovely if they would create a form that includes everything from the feds and the state side combined. But generally speaking, I think most employers pick one or the other. Anonymous attendee says, I registered with a date prior to 10/1. How do I fix it? Just go on it. Go into your account and correct it. If you have any trouble doing so, submit a contact us ticket and we can help you. What, if any, responsibility does the employer have once a claim is approved? Great question. As far as paid leave is concerned, the obligations are pretty minimal. You have to not discriminate. That's pretty much it. If the claim is approved, you've already given us the employment verification form. So really your focus is just making sure that you manage their FMLA leave. If an employee has maxed out their FICA wages for the calendar year, do you still deduct their paid leave for this quarter? Yes. So when we say up to the Social Security contribution limit, it's really a shorthand for up to that number, but you still have to pay us that amount. No one from a school has paid us any amount yet. So you would still deduct the Connecticut paid leave contribution from them for this fourth quarter. Next year, it'll all even out. What if we find we've been withholding for someone who shouldn't be withholding for? What do we do? So you've been withholding presumably for someone who's in a position that requires certification. Give them back the money. That's all. If they have filed a claim and we determine that they're ineligible, we will have to deny it, and then you're going to still have to give them back the money. So you may as well just correct your records now. Do we have to pay holiday pay if it's part of the CBA? What if we're paying the holiday itself? You have to do what your collective bargaining agreement tells you to do. That is sort of part of what's going on. Whatever we're paying is not full income replacement. And we may not be paying it at all, particularly given that from at least several of the major holidays, school may not be open, so they wouldn't be getting paid that week anyway. So really just focus on what your collective bargaining agreement tells you to do. I have someone from a private school. None of the staff is required to be certified, therefore everybody's covered. Yep, that's true. If nobody is required to be certified, then everybody's covered. If Connecticut and federal FMLA have been exhausted, but they haven't used up their Connecticut paid leave, could they still get benefits? Yes. So they could still get money from us. They just don't necessarily have a statutory entitlement to job protected leave. But we do see that happening. Actually, I should mention, even the recently unemployed folks could get benefits from us. Our statute says you have to be either currently employed or have been employed in the 12 weeks immediately before the benefits are needed. So, you could have somebody who stopped working for you in, at the end of the semester in December, and they're not coming back in January, and they apply to us for benefits in February. They're within that 12-week period, so they could get it. Can I explain section 3 of the application? So I think you mean the employment verification form. Do we need to record hours worked and PTO taken? If we're capturing the wages, is that sufficient? We do actually ask for schedule is in addition to wages. So we want both. The reason we look at schedule is because it helps us determine what their work week is, which is necessary for things like if they're taking reduced schedule leave, intermittent leave, or if their leave starts or ends, in a midweek situation. So we ask, what is their regular schedule? If they work a regular schedule, you can just tell us they work 30 hours a week. If they vary, that's when we say, well, tell us what they worked in the last 12 weeks. And we basically want to know, what my regular schedule is plus overtime. So if someone took PTO 2 weeks ago, you just include that as part of what they were sort of, this is a problem. Schedule means so many different things, but basically in a normal week, you would expect them to have worked 7 hours. They took a vacation day. They're still supposed to have accounted for 7 hours on their payroll. That's what we mean by hours worked and PTO taken. Hopefully that helps. I saw on a slide that we could reach out to AFLAC for questions on a filed claim. Is that before or after the forms are filled out? Actually, that's for the employee. So really, employers don't really engage with AFLAC very often. If you have questions, you can go to our website at ctpaidleave.org and submit a contact us inquiry, and we can help you with your questions. As an employee, if you have questions, you can call AFLAC to file a claim or to ask about your status of a claim. Sorry, I can correct the slide deck to make sure that that's a little bit more clear when we're talking to employers. So thank you for that. All right. Oops. Is the status of filed considered before or after all the claims are completed? So when you're an employee who's filing a claim, you start your application telling us your leave reason, your estimated dates of leave, and then we send out the forms. So once you start, that means you filed it. It's not necessarily completed. All right, we are coming to the end of the hour. Again, I know I owe you some questions about sick leave. Oh, If PTO is separated into sick and vacation, does it matter what bank they hold the 2 weeks from? No, DOL says it just has to be 2 weeks. So, it's not really they don't really care so much about that. Does the withholding period start on October 1st? It starts as of the first paycheck issued on or after October 1st. Okay, so, even if you pay in arrears, so your October 1st applies to, um, prior to October 1st, that covers. Someone says, we started on our 10/10 payroll that covers 9/22 through 10/3. So, perfect, you did that correctly. And then you would, again, we just sort of care about your, the paycheck, the sort of the date of the payroll. So, um, hopefully that helps. I can, if you want to send me your information so that I can, if it doesn't help you, if you give me your actual information, I can have my finance folks give you more specific information about like how the dates get entered into the contribution remittance. Okay. It is 2:01. If you are still here, I appreciate your willingness to stay with me this whole time. Again, we will share the slides and the recording. I know we owe some answers to questions about the stipends, so we will get those out as well. And hopefully this was helpful. Again, I encourage you to check out our website at ctpaidleave.org for more information about the program, for the job aids about completing the employment verification form, and for information about how to register and how to remit your contributions. Thank you so much for your time today and have a lovely afternoon.